Article 11, Justifying Circumstances. These are defined as those circumstances where the act of a person is said to be in accordance with law, so that such person is deemed not to have transgressed the law and is free from both criminal and civil responsibility. In this article, we say that there is neither a crime nor a criminal, and that is why, as we've said, there is no civil liability, except, of course, in paragraph 4 on state of necessity. With respect to the burden of proof, remember that as a general rule, conviction must rest on the strength of the prosecution and not on the weakness of the defense. We've heard that so many times before. But when the accused admits the killing induced by the presence of a justifying circumstance, the rule will be reversed and the onus probandi shall rest upon the accused to prove the existence of a justifying circumstance in his favor by clear and convincing evidence. Otherwise, conviction will follow on the basis of his own admission. This is because pleading a justifying circumstance is in the nature of a confession and avoidance. That is why we say that in such a case, the accused must rely on the strength of his own evidence and not on the weakness of the prosecution. There are 6 paragraphs in Article 11. Let's begin with the first, self-defense. Anyone who acts in defense of his person or rights, provided that the following circumstances concur. Number 1, unlawful aggression. Number 2, reasonable necessity of the means employed to prevent or repel it. And number 3, lack of sufficient provocation on the part of the person defending himself. Now, why is self-defense lawful? The state cannot in all cases prevent aggression to its citizens and residents and offer protection to a person unjustly attacked. On the other hand, man always has this instinct of self-preservation. He is not expected to succumb to an unlawful aggression without the slightest resistance. Now, self-defense must be proved with certainty by sufficient, satisfactory, and convincing evidence that excludes any vestige of criminal aggression on the part of the person invoking it. And of course, it cannot be justifiably entertained where it is not only uncorroborated by any separate competent evidence, but when in itself it is extremely doubtful. Now let's discuss the requisites of self-defense, beginning with the first, unlawful aggression. This is the most indispensable requisite in self-defense. Without it, there can be no self-defense, complete or incomplete. There would be nothing at all to prevent or repel. In short, the second and third requisites presuppose unlawful aggression. And what is the definition of this unlawful aggression? It is equivalent to assault, or at least threatened assault of an immediate and imminent kind, as opposed to merely a threatening or intimidating attitude. There is unlawful aggression when the peril to one's life, limb, or right is actually is actual or imminent, or when there is actual physical force or actual use of a weapon. Unlawful aggression can therefore be broken down into the following elements. Number 1, there must be a physical or material attack or assault. Number 2, the attack or assault must be real or imminent. And number 3, the attack or assault must be unlawful. At this point, we can say that not all aggression is unlawful. There is what we call lawful aggression. For example, A police officer firing shots in the air to warn escaping detainees, that would be a lawful aggression. On the other hand, when an officer in authority exceeds his authority in fulfilling his duty, he commits unlawful aggression. For example, a public officer who beats up squatters in order to evict them, that would be unlawful aggression. What are the rights which must be defended under the law? These are the right to life, property, and honor. Let's discuss first the right to defend one's chastity and honor. If a husband catches his wife and paramour in the act of having sexual intercourse and he kills the paramour, the husband would not be committing a felony, as there would be an absolutory cause, that which we know as Article 247, death or serious physical injuries inflicted under exceptional circumstances. But suppose that the reverse happens. Let's say the paramour kills the husband while defending himself from the assault of said husband. The paramour here cannot invoke self-defense. The attack of the husband would not be a felony to begin with, hence it would not be deemed unlawful aggression within the contemplation of self-defense. The paramour who has been maintaining illicit relations with a married woman ought to have known that he is performing an unlawful and criminal act, thus exposing himself to the vengeance of the husband. That was the ruling of the court as early as in November 1918, U.S. versus Merced. The belief, however, that there is danger to one's honor must have some rational basis in our jurisdiction in order to justify killing based on defense of honor. There must be proof at the very least of an attempt to rape the accused by the deceased and not just acts of lasciviousness by the latter. This was the ruling of the court in People versus Jauregue, if you remember. The court said there that it's not enough that the person making the defense believed that her honor or life for that matter was in danger. The belief must have some rational basis. Let's give another example. Suppose that it was 3 o'clock in the morning. A woman was walking in a dark alley, and when a man behind her started to touch her private parts. The woman had a gun in her bag, which she ultimately used to kill this man. Would there be a rightful defense of honor? The answer is yes. Consider the place and the occasion of the assault by this man who jumped from behind the woman. During an emergency, human nature does not act upon a process of formal reasoning, but acts on the instinct of self-preservation. When there is danger or the threat thereof subsists, the controlling inquiry is, would the defense be reasonable? The necessity need not be real or actual, it need only be reasonably apparent. Now, suppose that this incident happened at about 6 o'clock p.m. and there were other people on the street. A woman was walking and suddenly the man jumped from behind her and touched her breasts. She gets a knife from her purse and kills this man. There would not be self-defense, because then there might be lawful aggression, definitely, on the part of the man, but of course the means used by her to repel that aggression was not reasonable. Let's go to defense of property. Uh, the old doctrine, which we call the Apollinar doctrine, has been abandoned, and in that doctrine, the court ruled that a prior assault against the person of the owner or caretaker of the property is necessary before the latter can perform any defensive action. Let's give some examples. By the way, this Apollinar doctrine has been abandoned. The present ruling now is that there need not be a prior assault upon the accused before he can make a rightful defense of his property. But of course, in defending his property, he must not kill the victim, because the value of property can never equate the value of life. So that again, while there may be an unlawful aggression on the property, the means must still be reasonable in order to repel such aggression. Suppose that accused is let's say X is the driver of a car owned by his employer. Let's make him the caretaker, therefore. One night, two men were forcibly getting the keys from X. And X, in order to maintain possession of the keys, punched these two men, and he ran away. Would this be a proper defense of property? Yes, because as we've said, even if these two men weren't punching him, they were just grabbing the keys from him. A prior assault upon the accused, who is defending his property, would not be necessary anymore. But if the accused shot this one of these men in the leg or any part of the body of that man, would he be justified, considering that his person was not at all being assaulted or threatened? This time the answer is no. Article 49 of the Civil Code has been a number of times complementary to defense of property. And under Article 49, the owner or lawful possessor of a thing may exclude anyone from the enjoyment thereof and may use such reasonable force as may be necessary. A reasonable force should not lead to a deliberate infliction of serious or less serious physical injuries. Reasonable force is that amount of force which would be commensurate to the aggression upon the honor, the property, or life of an individual. To repeat homicide in defense of property is excusable only when necessary to defeat or prevent the commission of a forcible or atrocious felony against the owner. Under no circumstance must the person defending the property kill or seriously injure the intruder, unless there is an actual or at least threatened violence or surprise, because the right to possess or own property is inferior to the right to live. In one case, X and Y are neighbors. One day, X blocks the fence of Y, and therefore Y is prevented from accessing the highways. Y went inside X's house and there struck X on the latter's leg with a bamboo stick. Will Y be justified? The answer is no. Y may resist an attack on his property under Article 429 of the Civil Code only at the very moment of attack against his property, because, as Article 45 provides, the owner or lawful possessor of a thing may exclude anyone from the enjoyment thereof and may use such reasonable force as may be necessary. So that if while Y is constructing the fence which would block Y's access to the highways. That's when Y pushes X in order to stop X from continuing the fence or with the fence. Y would be justified in performing such an act because in that case the force employed would have been reasonable. Now, if it is the dwelling or home that is being defended, the owner, with more reason, need not wait for an assault against his person or property, but it is important that he considers the manner of entrance by the assailant. The entrance should show a positive determination to injure the owner of the house. Let's give an example. Suppose that the accused and his family live in a gated community in Quezon City. One night, four armed men violently went inside their home with a machine gun, pointed at the walls just to make sure that if anyone came out of the room, that person would be hit. Upon seeing these men, the accused, the owner of the house, shot them. Can the accused justify his defensive action? Yes, that would be defense of home. Consider the fact that these men were armed, the manner of their entry, and the fact that these men had aimed their firearms at strategic portions of the wall, just in case, as we've said, any one of the owners got out of their respective rooms. In that case, the accused need not wait for a blow before repelling the aggression, as the blow may prove fatal. Now, how about if these men entered unarmed? Would the accused be justified in shooting them? After all, these are strangers in his house at unholy hours in the evening. The accused would not be justified in shooting any of them. It is only when it is impossible to ascertain how far a person will go to take another person's property away can force be applied upon him. And that's not even enough. It must be that that person intruding on another's property exhibits some manner of force showing an intent to cause violence, where the accused does not have to act according to his natural instincts. The law of reason, which counsels against the taking of human life, supersedes the law of the jungle, which demands survival of the fittest. Let's, while we are still at the subject of property or defense of property, let's differentiate between mere disturbance of possession and real dispossession. When we say mere disturbance of possession, force in order to prevent that disturbance from continuing may be used anytime as long as the disturbance intended to cause dispossession continues. For example, if a ditch is opened by X in the land of Y, the latter may cover such ditch by force anytime. On the other hand, if it is real dispossession, the force in order to regain possession may be used at the time of the dispossession or immediately after the dispossession. So if X, without the permission of Y, picks up the latter's watch and runs off with it, X can pursue Y and recover the watch by force. Reasonable force, of course. On the other hand, if the property is an immovable, there should be no delay in the use of force to recover it. Delay, even if excusable, such as when due to the ignorance of the dispossession, uh, that will bar the right to the use of force. Once the usurper's possession has become firm by the lapse of time, the lawful possessor must resort to authority to recover his property. In other words, in cases involving dispossession of real property, the court said that when possession has already been lost, the owner must resort to judicial processes in claiming the remedy. This is clear from Article 536 of the Civil Code, which provides that in no case may possession be acquired through force or intimidation as long as there is a possessor who objects thereto. He who believes that he has an action or right to deprive another of the holding of a thing must invoke the aid of the competent court if the holder should refuse to deliver the thing. Um, Let me just correct myself with what I said earlier with respect to real dispossession. Um, if property is movable, there should be no delay in the use of reasonable force to recover it. Delay, even if excusable, such as when due to the ignorance of the dispossession, will bar the right to use of force. It should be if the property is movable, because later on we said that in a case involving dispossession of real property, the owner must resort to the judicial process in claiming the remedy. Now, let us talk about the last right to be defended, the right to life. I think it is clear that the person making the defense must perform such defensive action against the source of aggression. Because in self-defense, the unlawful aggression must have come from the person who was attacked by the accused. Now, an important point to consider in cases of defensive actions with respect to life is that the aggression should not be merely imagined. Let's give an example. Suppose the deceased was fired from work. He was very angry. He started screaming invectives at his employer. And the deceased's eyes were very huge, bloody red from fury inside of him. As he approached the employer, the latter shot the deceased. Can the employer interpose the unlawful aggression of the deceased as a defense? After all, this deceased was shouting invectives at him. The answer is no, because to constitute unlawful aggression, the peril to one's life must be actually present or at least imminent. It is necessary that an attack or material aggression, an offensive act possibly determining the intent of the aggressor to cause an injury, should have been made. In this case, the deceased may have acted arrogantly towards his employer, but such behavior did not really pose a real threat to the life and safety of that person claiming self-defense. In the case of People versus Rubiso, the court said that assuming that the deceased had a gun and pulled it, records show that the deceased did not manifest any aggressive act which may have imperiled the life and limb of the accused Rubiso. The court said that the mere thrusting of one's hand into his pocket, as if for the purpose of drawing a weapon, is not unlawful aggression. Even the cocking of a rifle without aiming the firearm at any particular target is not sufficient to conclude that one's life was in imminent danger. Hence, a threat, even if made with a weapon, or the belief that a person was about to be attacked with a weapon, is not sufficient. It is necessary that the intent be ostensibly revealed by an act of aggression or by some external acts showing the commencement of actual and material aggression. That was what the court said in People versus Robiso, a 2003 case. Now, in 2018, we have People versus Enrique Reyes. In that case, the court said that the drawing of a gun is not unlawful aggression. It is only when a gun is aimed at a person that such person may claim self-defense. The court there said that there is nothing in the records which would convincingly prove the claim of the accused that his life was in danger when he saw the deceased. In that case, it was proved during the trial that the deceased was on his way home after tending to his fighting cocks, and the deceased was 3 steps away from his house when the accused, Enrique Reyes, suddenly fired his Armalite at him. Witnesses also testified that the gun of the deceased was tucked in his waist. On the other hand, the accused was saying that the deceased had been holding a gun when he shot the deceased. Overall, the court said that the accused failed to show an attack so offensive, menacing, and strongly indicative of an intent to cause injury as to justify the killing of such deceased. Based on the facts of this case of People versus Enrique Reyes, the decision would be a sound decision. However, the bothersome part of this decision is a statement by the court that unless the gun is aimed at a person, the life of the person is not in danger, so his right to defend himself is not present. In fact, the court even repeated or cited the Robiso ruling that even if the rifle is already cocked, if it's not yet aimed at any particular target, that's not unlawful aggression. But you'll never know if, the saying that a person who draws a gun would most likely use it. But of course, that's the ruling of the court. Remember the ruling. As long as the gun is not yet aimed at an individual, that individual has no right to kill that person holding the gun. Okay. The general rule, therefore, is that the mere act of drawing a gun from one's waist does not constitute unlawful aggression because it does not put in peril the life or limb or personal property of the accused. However, in 2012, the court already said that this general rule admits of an exception, that is, when special circumstances are attendant. And that was the ruling of the court in Naknak versus People, dated March 21, 2012. The court in Naknak said, ordinarily, there is a difference between the act of drawing one's gun and the act of pointing one's gun at a target. The facts surrounding the case, however, must be differentiated from that jurisprudence on unlawful aggression. The court said that in the case of Lolito Naknak versus People, the victim was a trained police officer himself, and this police officer was drunk and had disobeyed a lawful order of a superior. Um, he wanted to settle a score with somebody, an old enemy, and the deceased wanted to use a police vehicle, and accused appellant Naknak, the superior of the deceased, would not want to lend the police vehicle to the deceased. But as the deceased continued, a warning shot was fired by a superior, and the deceased did not care about this warning shot. And not only that, he reached for his own firearm and pointed it at Naknak. So Naknak was therefore justified in defending himself from an inebriated and disobedient colleague. In fact, the court said that even if it were to believe the claim that the deceased had really pointed his firearm at accused petitioner Naknak, there would still be a finding of unlawful aggression on the part of the deceased. And the court said, and let me quote, "A police officer is trained to shoot quickly and accurately. A police officer cannot earn his badge unless he can prove to his trainers that he can shoot out of the holster quickly and accurately." Given this factual backdrop, there is reasonable basis to presume that accused appellant Naknak indeed felt that his life was actually threatened, and facing an armed police officer like himself, who at the time was standing a mere 5 meters from the accused appellant Naknak, the latter knew that he had to be quick on the draw. It is worth emphasizing, said the court, that the victim, being a policeman himself, was presumed to be quick in firing. End of quote. So again, remember the general rule. The general rule is that stated by the court in Enrique versus Reyes. The drawing of a firearm is not unlawful aggression. It is unlawful aggression only when the firearm is aimed at somebody. Now, the exception is Naknak versus People. If the person who drew the firearm was a police officer or any person trained to shoot quickly, the person against whom such firearm is drawn was justified or would be justified in shooting this drunken police officer. Of course, with respect to peril to limbs, remember that a slap on the face is unlawful aggression. Suppose that X and Y are arguing, and in the middle of the argument, X slapped Y. That is unlawful aggression. If Y had punched X, he would be justified in that action because that would be a reasonable means of repelling such an affront against the honor of the individual. Our face represents our honor, so a slap on the face is an aggression on our honor. But if the person slapped kills the slapper, that would not be self-defense because the requisite of reasonable means would be missing. Remember the rulings of the court. Playful greeting, even if somebody parts are touched, do not constitute unlawful aggression. Frolics do not constitute unlawful aggression. In one case, the deceased liked touching and slightly hitting his friends. and that's what he did to the accused. He said that he had no voice, so he was touching or probably pushing the accused. After words were exchanged between them, and in a spirit of fun, the deceased seized the accused by the throat, whereupon the accused killed the deceased with his rifle. The court said that the fact that deceased seized the accused by the throat and in fact exerted pressure thereon in one of his frolics, which he had persistently kept up with notorious imprudence, and in spite of the opposition of the accused, still that cannot be considered as an unlawful aggression in the case of two companions in arms who were even quartered in the same barracks. Let's talk about threats. The threatening attitude must be offensive and not merely imaginary. In other words, threatening attitude per se is not unlawful aggression because that would be imagined aggression only. It is only if the threatening attitude is accompanied by an offensive action showing a positive determination to cause violence would that threatening attitude or would that threat be considered as unlawful aggression. Be that as it may, oral threats are not sufficient because an unlawful aggression refers to an attack that has clearly broken out or materialized or at least imminent. So insulting words without physical assault cannot constitute unlawful aggression. So, if a student was advancing towards his professor who had just given him a failing mark, and let's say the student's hand is in his pocket as if grabbing something, and what did the professor do? He shot the approaching student whose hand was in his right pocket as if he was grabbing something. Court said in People versus Padin, this was not unlawful aggression. This was just a mere threatening attitude. A mere threatening attitude of the victim, such as the pressing of his right hand to his hip where a revolver was holstered, accompanied by an angry countenance or like aiming to throw a pot, is not sufficient to constitute unlawful aggression. In fact, the mere act of holding a knife in a threatening manner without initiating an attack does not constitute unlawful aggression. Now, if the offender opens the knife, let's say a folded knife, opens it and motions with his hand again, thrusts the knife against the other individual, then that would be unlawful aggression. That would be an initiation of an attack. Let's talk about retaliation. When the act of the aggression is a response to an insult or a threat, it cannot be considered as a defense. It would now be a punishment which the injured party inflicts on the author of the provocation. And in such a case, the courts at most will consider this as a mitigating circumstance. Let's give an example. Suppose that X calls Y, his neighbor, impotent in public. Okay? You're an impotent, no wonder you don't have a child. And the person who was insulted draws out a knife and lunges at the individual who had just called him an impotent. The act of aggression by this impotent would be considered as his response to the insult. In other words, that would be an act of retaliation. Let's give another example. Suppose that X, a bachelor, met Y at a party and he managed to take Y home. In the car, they started to kiss. Soon, X discovered that Y was not a lady but a man. X punched Y and kicked him out of the car. Y, however, refused to leave. For some reason, he just didn't want to leave the car. Instead, Y, the person who had pretended to be a lady, stabbed Bachelor X. Can Y interpose the unlawful aggression on the part of X as a defense, or as a reason for his defensive action? The answer is no, because what Y did was to retaliate. When a person, X in this case, had inflicted physical injuries on another without intent to inflict further injuries, and that other attacks the former, that other one making the attack would be the unlawful aggressor, because such attack would be deemed a retaliation. In retaliation, the aggression that was begun by the injured party had already ceased to exist when the accused attacked him. On the other hand, in self-defense, the aggression still existed when the aggressor was injured or disabled by the person making the defense. So in that case, if the uh, person being kicked out of the car, out of a moving car, let's say if he didn't do anything, he would be kicked out of the car, and he might be run over by the other vehicles. Suppose that in order to not be kicked out of the car, he punched this person so hard. Would that be self-defense? That would be self-defense, because the aggression still existed when he punched the bachelor. Now, how about if he stabs the bachelor? It would depend on whether, as we've said earlier, in kicking the person who pretended to be a lady, there was danger that he would be thrown out of a moving vehicle on the street, on the road. Then that would be another story. If that act is reasonable, then self-defense would be available. One point, the belief of the person making the defense is important. It may be considered in determining the existence of unlawful aggression. Suppose that two friends, one day, let's say X and Y are friends. One day X approaches Y with a gun pointed at Y. Y tells him to stop. It's not funny, but X, with angry tone, he starts to talk in an angry tone with a pistol pointed at him. And so Y took a golf club and hit X on the head, causing X's instant death. Turns out that the pistol being held by X was a toy gun. Can the accused interpose unlawful aggression on the part of his deceased friend? The answer is yes, because the belief of an accused may be considered in determining the existence of unlawful aggression. He cannot be expected to stop and ask X if the pistol was authentic. Now, suppose that the person approaching the accused holding a knife was a toddler, and the person shoots a toddler. That would not be self-defense. It is not enough that the person making the defense believed that his life was in danger. The belief must have some rational basis. Otherwise, the defensive action resorted to in that connection would be unreasonable. Let us talk about agreement to fight. When there is an agreement to fight, there is no unlawful aggression. Each of the protagonists is at once the assailant and the assaulted, and neither can invoke self-defense because aggression, which is but an incident in the fight, is bound to arise in one or the other. That is more or less the same rule when there is mutual aggression. Even if the victim with the weapon assaulted the accused first, if the latter got a weapon inside his house and confronted the former outside, the plea of self-defense will be rejected. By confronting the victim, the accused accepted the challenge to fight and exposed himself to the consequences of the fight, so that he could not successfully plead self-defense, since mutual unlawful aggression cannot be the basis thereof. Let's give examples for these two principles. If X and Y had agreed to fight at the football field, let's punch each other in the football field. Whoever remains standing will continue to court the woman that we both like. That was to be at 4 o'clock at the football field. Suppose that on the way to the football field, X is unaware that Y was walking behind him. And before reaching the football field, before that time agreed upon, the person in the back shot the person in the front, or hit the person in the front with a, let's say, with a gun on the head. Then there is unlawful aggression on the part of the person in the back. When aggression is committed prior to the time agreed upon and in a place other than that agreed upon to be the venue for the fight, then that would be unlawful aggression. Know that the attack and the defense must be more or less simultaneous. To justify homicide on the ground of self-defense, the killing of the deceased by the defendant must be simultaneous with the act made by the deceased, or at least both acts succeed each other without appreciable length of time. Suppose that X and Y are arguing. All of a sudden, X brings out a knife, and of course, Y wants to get possession of that knife. So they are fighting for that knife. The knife fell from the hand of X. Y picks up the knife right away and stabs X. Will Y be justified in that stabbing? It depends. In order to justify homicide on the ground of self-defense, the act of killing the deceased, must be simultaneous with the attack made by that deceased. Let's talk about physical evidence. Let's say that during the autopsy conducted on the body of the deceased, it was found that he bore 5 stab wounds in the back. Can the accused in that case invoke self-defense? No, because the location, number, and seriousness of the stab wounds would belie the claim of self-defense. A lot of wounds would indicate that the accused had been determined to kill the victim. Know that flight is evidence of guilt, even in self-defense. So instead of keeping silent, let's say X or the accused tried to run away, it would be difficult for him to invoke self-defense, because flight after killing is highly evidentiary of guilt and is incompatible with self defense. Know also that when the fight is in two stages, the aggressor in the first stage may be the victim in the second stage. Let's give an example. Suppose that A and B were neighbors who never got along. One day they had a heated argument and both went down the stairs of their respective houses, or at least that was what A thought. But unknown to A, B had with him a bolo, a spear which he used to strike A on the leg, and then on the other leg. Unknown to B, A had a pistol, and when his two legs were struck, A shot B in the abdomen. B ran as fast as he could. A followed him and killed him with two gunshot wounds. Can A interpose the unlawful aggression of B as a defense? The answer is no. When the unlawful aggression which began no longer exists because the initial aggressor had run away, the one making a defense also loses his right to kill or even wound the aggressor. The aggression began by B in the first stage of their fight no longer existed when he took to his heels. A here should have stayed his hand. A therefore cannot invoke self-defense because the unlawful aggression of B earlier had already disappeared. Now, in claiming self-defense, the court will consider the time during which the mortal wound was inflicted. Suppose that X ran after Y with a long spear, then Y decided to meet X head on, and Y successfully was able to get hold of that spear, and then he stabbed X. Let's say that before he stabbed X, X was, still lunging at him, albeit without any other weapon, because the other person had been able to grab it from him. Uncertain whether he had completely disabled X, Y stabbed X some more, a few more times in the legs. Can Y interpose self-defense? The answer is yes. When only minor wounds were inflicted after the unlawful aggression had ceased, there would still be unlawful aggression as long as the mortal wound was inflicted at the time that the requisites of self-defense were still present, as long as the minor wounds did not contribute to or hasten the death of the victim. What is the meaning of standing one's ground when in the right? When is a person justified in standing ground when in the right? The standing ground when in the right doctrine has abandoned the retreat doctrine. In the retreat doctrine, the person being assaulted must have really, been run after until the point where he has reached the wall. In other words, he has reached the end of the road, and that's the only time that he can begin to defend himself. Under the retreat rule, it is the duty of the person assailed to retreat as far as he can before he meets the assault with force. It means that the defender has reached the wall and has no more place to run so that he can now defend himself. And as we've said, it's no longer observed in our jurisdiction. It has replaced the standing ground. What has replaced the retreat doctrine, pardon me, is the standing ground when in the right doctrine. It is not the nature of the force defended against which raises the issue of retreat, but the nature of the force which the accused employed in his defense. Where the accused is where he has the right to be, the law does not require him to retreat when the aggressor is rapidly advancing towards him, because the aggressor might hit him in the back. That's simply it. Okay. Suppose that accused was sound asleep when she felt a man on top of her. Believing that the man was her husband, accused allowed this man to have sexual intercourse with her. After the act, accused discovered that the man was not her husband, and so she killed him. Would she be justified? The answer is no, because the unlawful aggression consisting in the act of rape against her chastity had ceased. But she would be entitled to the mitigating circumstance of vindication of grave offense. The same result would arise when a father catches a man raping his daughter and then chases this man and shoots the man to death. Of course, there would be the mitigating circumstance of passion and obfuscation. Last point on unlawful aggression. As a rule, when the aggressor has been disarmed, the unlawful aggression ceases. However, it cannot be said that the aggression has ceased if there was a possibility, as shown by the aggressive attitude of the deceased, that he can still regain possession of the weapon. So if this were a continuous struggle, let's say X was the one who brought out the gun and Y was able to grab this from him. Let's say Y shoots X. Would Y be justified? We know that at the time that Y shoots X, the aggression of X has ceased because he has been disarmed. But if Y can prove that there was still a possibility that X could regain possession and shoot him instead, then the court would sustain his defensive action. Let's go to the second requisite of self-defense, reasonable necessity of the means employed to prevent or repel the aggression. There are two requisites here. There should be a necessity of the course of action taken by the person making a defense, and there should be a necessity of the means used, and both must be reasonable. The court said that the gauge of rational necessity is to be found in the situation as it appears to the individual who is the object of the aggression. Because in self-defense, the paramount consideration really is the instinct of self-preservation. Suppose that A and B were arguing violently, and then A picked a knife from his pocket. What should B do? When the intent to hurt is manifest, as where A clearly indicated his intention to use his weapon against B, lunging with it towards B, then B would have a perfect and indisputable right to prevent the impending attack by wounding A, and if necessary, to disable A completely. The law does not require B to expose himself to being wounded or killed. Suppose that in defending himself, uh, B wounded A in A's abdomen, a vital part of the body. Should not B have aimed at less vital organs of the aggressor? The answer is no, because the person defending is not expected to control his blow. He should not be expected to think clearly and draw fine distinctions as to the extent of the injury which a reckless and an infuriated assailant might probably inflict upon him. But in any case, the person making the defense must not be negligent. So let's say in defending himself, uh, this person uses the weapon indiscriminately, fires indiscriminately, killing not only the person who had assaulted him, but a bystander. Then that would not be self-defense, because in repelling an aggression, the one defending must aim at his assailant and not fire indiscriminately. Okay, actually, there would still be self-defense with respect to the person who had assaulted B, with respect to uh, B's firing at A. But with respect to B hitting a bystander with the same bullet or with another bullet, that would be negligence, and he would be liable for the injury or death of that bystander. What is the doctrine of rational equivalence? The doctrine of rational equivalence simply tells us that uh, the law does not require perfect equivalence in the choice of means to defend oneself. The law requires only rational equivalence, in the consideration of which will enter as principal factors the nature of the emergency, the imminent danger that the person attacked is exposed to, and the instinct, more than reason, that moves or impels the defense, and the proportionality thereof does not depend on the harm done, but rests upon imminent danger of the injury. Perfect equality between the weapons used by the aggressor and the person defending himself is not required, because the person assaulted does not have sufficient tranquility of mind to think, to calculate, and to choose which weapon to use. Suppose that A had a spear which he attacked B with. B, meanwhile, had a gun which A didn't know about. Will B be justified in shooting A? The answer is yes. The use of a revolver against a knife, a dagger, a spear is subject to the following limitations. Number one, there is no other available means. Number two, if there were other means, the one making the defense could not choose the less deadly weapon to repel the aggression. In this case, B would be justified in using his pistol to stop his aggressor before the latter gets close enough to hack him with a spear. B is not required to wait until the blow is delivered, because it is not necessary that the assault be actually perpetrated upon the intended victim before the latter may reasonably defend against it. Let's talk about fist blows. Suppose A punches Y. Will Y be justified in stabbing X. Suppose X punches Y, will Y be justified in stabbing X? As a general rule, no. The court said in People versus Montalvo that fist blows must be repelled with fist blows also, unless there's a big difference between the parties in terms of their build. Uh, the court in People versus Sumikad, a 1932 case, said that a man is not justified in taking the life of one who assaults him with his fists only, with the use of a dangerous weapon. The person in such a case must resist with the arms that nature gave him or with other means of defense at his disposal. That rule, however, contemplates a situation where the contestants are in the open and the person assaulted can exercise the option of running away. It can have no binding effect if the person assaulted has retreated to the wall, as the saying goes, and uses in a defensive manner the only weapon at his disposal. One is not required when hard pressed to draw fine distinctions as to the extent of the injury which a reckless and infuriated assailant might probably inflict upon him. In one case, the deceased was unarmed, but he was a huge man who who pinned accused to the ground, who actually punched the accused, who fell to the ground because of this strong fist blow. And it would seem that the deceased would continue punching him, and the accused shot this deceased. The court said that considering, if the physical constitutions of these two persons vary greatly, the accused would be justified in shooting the person who had just punched him if that person showed a determination to inflict serious harm upon the accused. The third requisite of self-defense is lack of sufficient provocation on the part of the person defending himself. Distinguish provocation from aggression. These terms are different. Provocation is an unlawful utterance or conduct capable of annoying another individual. Aggression, on the other hand, is any inordinate or excessive action. Suppose that the common law wife refuses to resume illicit relations with the accused who killed her. In the case of U.S. versus Hicks, that was not sufficient provocation according to the court. Suppose that a police officer saw the accused snatching the bag of the lady. The police officer ordered his subordinate police officers to arrest the snatcher. The snatcher killed the chief of police. The snatcher, during trial, said that he was provoked by the mayor's actuations. Is that position tenable? I'm not the mayor. The chief of police's actuations, is that position tenable? The answer is no, because provocation implies an unlawful act, and arresting a wrongdoer is not an unlawful act. Suppose that X arrives home. He sees under the, somewhere in the terrace, his wife kissing with another man. Of course, if his wife was having sex with another man, the husband would be justified in killing any of them or both of them. But in this case, the husband just saw his wife kissing another man, and he was now going to assault this man, but the man, unknown to the husband, was a policeman with a gun, and this man shot the husband. Can the policeman say he shot the husband in self-defense? No, because he the last requisite would be absent. The policeman had given sufficient provocation. There was no lack of provocation on the part of the person defending himself. In order for provocation, uh, the provocation would not be present if, of course, no provocation at all is given uh, by the how do I say this? Okay, when will you say that the third requisite is present? Sorry about that. The third requisite is present, that is lack of provocation on the part of the person defending himself, if number one, no provocation at all is given to the aggressor by the person defending himself. So if the husband arrives home and sees a man talking to a woman or to his wife, they were not kissing at all, he was just talking to the wife. Turns out this was a cousin from the province. Then no provocation at all was given by this man. So that if the husband was about to stab this man and the man shot the husband instead, you cannot say that provocation was given by this man. Next, even if provocation was given, it was not sufficient. Suppose that let's say, when is provocation not sufficient? Suppose that when the husband arrives and he asks, "Who is this man you're talking to?" And the man says, I'm your wife's friend. What's wrong with having a friend?" And so forth. That's not sufficient provocation. Third is, even if the provocation is sufficient, it's not given by the person defending himself. And the last is, even if sufficient provocation was given by the person defending himself, it was not the proximate and sufficient cause of the aggression. Okay, let's now go to the second justifying circumstance, defense of relatives. The reason for this justifying circumstance is founded not only upon a humanitarian sentiment, but also upon the impulse of blood, which impels man to rush on the occasion of great perils to the rescue of those close to them by ties of blood. But the requisites must be present. The first, unlawful aggression. Second, reasonable means to prevent or repel the aggression. And the last, in case provocation is given by the person attacked, in other words, the relative being defended, that the relative making the defense had no part therein. The relatives contemplated in this circumstance include relatives by consanguinity within the fourth degree and relatives by affinity in the same degree as parents, siblings, and legitimate adopted natural children. In other words, your parents-in-law are your relatives, your sisters and brothers-in-law are your relatives, and your children-in-law are your relatives insofar as paragraph 2 of Article 11 is concerned. Now, suppose that a man and a woman they were married, but they had obtained a decree of annulment. In light of that decree of annulment of their marriage, the relationship by affinity created between either spouse and the relatives of the other spouse is destroyed. So his former mother-in-law is no longer his relative. That would now be a stranger. Now, on the other hand, the relationship by affinity created between the surviving spouse and the relatives of the deceased spouse survives the death of either party to the marriage which created the affinity. So, if husband and wife were together until she died, her relatives remain as relatives by affinity of her husband. That is that is what the court has said in the intestate estate of Manolita Gonzalez Viuda de Corongcong versus People. Of course, the issue here was not really defensive action of for a relative. Suppose that while killing the deceased, the accused brother recalled all the times that the deceased had insulted him. Would accused still be in defense of relatives? Of the relative here? The answer is yes, because unlike in defense of stranger, good motive is not essential in the defense of relative. This is because the law recognizes the natural, moral, and legal duty of a person to protect his loved ones and assumes that he defended the latter in response thereto, as he would in defense of himself. Therefore, as long as all the elements of defense of relative are present, the accused will be acquitted. Now, suppose that X and let's say X is sleeping. While X is sleeping, two brothers, A and B, A told his brother to kick X just for fun, which the brother did. This awoke X, who was very upset. He was now gonna stab the brother, and A saw this, and A shot X before X could stab the brother of A. Would A be justified? Would that be defense of relatives? No, because the last requisite would be missing. A here participated in the provocation. Suppose that X and Y agreed to fight and both pulled out their respective knives. The brother of X, let's call him B, was present when this agreement was reached. B is now watching the fight, and now he sees that his brother X would be the losing party. Let's say that Y is now about to stab X, and upon seeing this, the brother of X shot Y. Can the brother of X invoke defense of relatives? The answer is no. When two persons are ready to strike each other, there could not have been unlawful aggression from either. In other words, there's mutual aggression here. Not only mutual aggression, there's actually an agreement to fight. And we said that when there is an agreement to fight, that kills unlawful aggression. And just like in self-defense, unlawful aggression is still the most important requisite in defense of relatives. At most, there will only be a mitigating circumstance to be appreciated against X. Suppose that X and Y were arguing, and this argument was going on in the presence of B, the brother of X. In the middle of the argument, X pulls out a knife. Y tries to wrestle the knife away from X and successfully does. And the brother of X stabs Y. Will the brother of X be justified? The answer is no. What justifies defense of relative is the actual knowledge, or at least reasonable belief, that the relative being defended is the victim or an innocent victim of the intended assault. Where the accused knows that his relative is the aggressor, because he has seen his relative bring out that knife, and with that knowledge he still attacks the relative's opponent, then it only means that he concurs in the aggression and the criminal design of the relative, and thereby becomes the relative's co-principal either by direct participation or indispensable cooperation, or maybe an implied conspirator in the commission of the crime. Suppose that A, B, and C decided that they would beat up another uh, neighbor. Let's call him X. They went to his house, confronted him, and they had a hostile argument. And then A struck the neighbor with a bamboo stick. The neighbor fell to the ground. While the neighbor was on the ground, B struck this person with a much thicker bamboo stick. X remains on the ground. C is now about to drop a huge piece of stone on the face of X. But before C could do so, X finally takes a revolver from his waist and aims it at C. At this point, the son of C is just approaching, and he sees this. He sees X about to shoot his father. What does the son of C do? He kills X with a spear, with a bolo. Can the son have the benefit of defense of relative? The answer is yes. The unlawful aggression can be made to depend on the honest belief of the one making the defense. Mistake of fact will surely apply. Let's now talk about the third. I'd like to give you one more example. Suppose that how come in our earlier example, when a person told his brother to kick a sleeping person, and the sleeping person is about to hit the brother, and now the inducer of the brother defends his brother by shooting this sleeping person first, he will not be able to invoke defense of relatives because he participated in the provocation. On the other hand, if he did not participate in the provocation, let's say X kicked Y and Y was sleeping. Y, of course, woke up very angry and is now about to shoot X, and B, the brother, sees this and he shoots Y. B will completely be justified because that is defense of relatives. He did not participate in the provocation given by the brother. Now, how about in the example where X and Y are arguing and it becomes violent? X brings out a knife and Y is able to get the knife and is now about to stab X. And seeing this, the brother of X shoots Y. In that case, we said earlier that the brother of X would not be justified. Why are there two different answers here? Because the first problem involves provocation and the second problem involves unlawful aggression on the part of the relative being defended. When there's unlawful aggression on the part of the relative being defended, even if the relative making the defense did not initially participate in that unlawful aggression, by defending his relative who is an unlawful aggressor, he is concurring in the aggression of that relative. Let us now go to the third paragraph, defense of strangers. The requisites are the same for the first and second. It is the last which differs. That the person defending is not induced by revenge, resentment, or other evil motive. Who are deemed strangers? Those not covered by Article 11, paragraph 2, the preceding paragraph. They would be strangers. The basis of defense of strangers is that what one may do in his defense, another may do for him, or he may do for another. Suppose that husband and wife, husband learned that his wife was having an affair with their driver. He confronted her and the argument became heated. Husband pushed wife to the ground and there he started to strangle his wife. The housekeeper, who didn't know what they were fighting about, but of course was just couldn't help but have sympathy over the wife. He furnished the wife with an ice pick, and the wife used it to stab her husband. That is defense of stranger. Furnishing a weapon to one seriously in danger may fall under the category of defense of stranger. Now, how about if it was the driver who threw the ice pick to the wife? Would the driver be justified? It depends on the motive of the driver when he threw the ice pick to rescue the wife. Of course, the presumption would be that the driver was induced by an evil motive. That would be a presumption. So he'd have a hard time invoking defense of strangers. Mistake of fact also applies to defense of strangers. Suppose a young man, about, let's say, 18 years old, was being pinned to the ground by two bigger and older men. Accused sees this, and he rushes to the aid of this young man and hits one of the bigger men with a bottle on the head. The bigger man turned out to be cops in plain clothes who were arresting this young man for selling dangerous drugs. Will the person defending the stranger be justified? In our jurisdiction, he would be justified. The modern view is not to impose criminal liability in connection with intent crimes for those who act with good motivation in a mistaken but reasonable misapprehension of facts. In a criminal proceeding, one is concerned with the acts against society and not with the wrong between individuals and the right to reparation, which is the province of tort. Let's now go to the fourth circumstance, avoidance of a greater evil or injury. This is the paragraph on state of necessity, which involves two unequal rights. The injury or damage in this paragraph does not refer to crimes against persons or property only. It may cover slander as well as other applicable crimes. The rationale for this circumstance is the instinct of self-preservation, because man always sees his own life as more important than the other person's life. This paragraph is not limited to sacrifice of life, but also to sacrifice of property. It is, however, only in this paragraph where there is civil liability. Why is there civil liability in this paragraph? The necessity underlying the first three justifying circumstances is unlawful aggression, and the object and the victim of the defensive action is the aggressor, the unlawful aggressor, who is neither a passive nor an innocent person. But in the fourth justifying circumstance, the act done to avoid the evil or injury is at the expense of an innocent person who had nothing at all to do with the existence of the evil sought to be avoided. Moreover, in the absence of an unlawful aggression, lives must be assumed to be of equal value, and one must not be justified in taking the life of another just to save his own. That is why the requisite is that the injury feared be greater than that done to avoid it. Suppose that a mountaineer is roped to a companion who has fallen over a, a precipice. The mountaineer cuts the rope to save himself, and in so doing, he avoids killing them both. But of course, the companion dies. That state of necessity. But suppose that for that particular, let's say that particular mountainous area, roping was prohibited. Would the mountaineer be justified? Of course not. When the accused is reckless or negligent in bringing about the situation, requiring the choice of evils, or in appraising the necessity for his conduct, then that would be the basis for his conviction. Let's give other examples. Suppose that X was convicted of estafa and sentenced to 5 years of prison correctional in prison. Suppose the conditions in the penitentiary were miserable, and so people kill each other almost every day, or killed each other almost every day. And X here started to fear for his life. One day he escaped from the penitentiary. Can he invoke paragraph 4? The answer is no. A person who is confined by law should only be delivered by law. Also, you must remember that unless how do I say this? A person confined by law should be delivered by law, and no other means can be justified in any case unless the officers in charge and the law itself refuse him relief unreasonably. Pardon me, I think I mixed the two problems. We have the case of Dempsey versus US. Suppose the defendant's escape, would that be justified? Let's say he was sick with diabetes and he was not being given insulin shots in the infirmary. It is there where the court said that he would not be justified because a person confined by law should only be delivered by the law, and no other means can be justified in any case unless the officers in charge refuse him relief. In any case, the evidence of the necessity must be clear and conclusive, and the act must proceed no further than the emergency requires. Of course, in our jurisdiction, nothing would justify the escape of any convict from prison. Please remember that. Other examples of state of necessity is when a doctor kills the fetus to save the mother. He performs an abortion to save the mother. Suppose that there's a speed limit for the vehicle, but this is violated by the driver in order to pursue a criminal. Now, remember that euthanasia is not covered by a state of necessity. Ending the life of the patient is a greater injury than prolonging his sufferings. If the victim does not die, there could be criminal liability for attempted or frustrated murder. In mercy killing, the accused himself decides to kill the patient to spare the patient from prolonged suffering. But if you remember your crime of giving assistance to suicide, it is a patient who has decided to end his life, but the accused lends assistance to this patient to the extent of doing the killing himself. Know that the evil which brought about the greater evil must not result from a violation of the law by the actor. Suppose that X and Y decided to rob. Okay, I'll just give that for your exams. Now, if Article 429 of the Civil Code complements the first paragraph, self defense, Article 432 of the Civil Code in relation to Article 217 also of the 74 also of the Civil Code and Article 101 of the Revised Penal Code supplement the state of necessity doctrine. In the case of Stan versus Standard Vacuum Oil Company, a truck of defendant company caught fire while delivering gasoline in one of its gasoline stations. To prevent the burning of the station, the driver drove the truck to the middle of the street and there he abandoned it. But the truck continued to move until it crashed against a house across the street and burns this house. The driver will be acquitted, but the truck company will be civilly liable. The court there said that the owner of a thing has no right to prohibit the interference of another with the same if the interference is necessary to avert an imminent danger and the threatened damage compared to the damage arising to the owner from the interference is much greater. The owner may demand from the person benefited indemnity for the damage to him. On the other hand, under Article 101, Paragraph 2 of the Revised Penal Code and Article 2174 of the New Civil Code, the right to indemnity of the person at whose expense the harm may have been prevented or avoided under Paragraph 4 of Article 11 is against the person or persons who have benefited from the act, in proportion to the benefit which they may have received, as the court, in its sound discretion, may determine. Suppose that let's say that there are so many passengers with so many luggages on the vessel. Say this is a cruise. All of a sudden, the vessel is starting to sink because it was overloaded. Or let's say that. Suppose that the captain orders the throwing of some of the luggages. Not all. Those whose luggages were thrown will suffer prejudice, of course. Those whose luggages were saved would be liable to the other passengers to the extent of the benefit derived by them from the saving of their luggages. Let's go to paragraph 5. Fulfillment of a duty or the lawful exercise of a right or office. The requisites are that the accused acted in the fulfillment of a duty or the lawful exercise of a right or office, that the injury caused or the offense committed be the necessary consequence of the due performance of such duty or the lawful exercise of such right or office. Please remember Rule 113, Section 2 paragraph 2 of the Rules of Court, no unnecessary or unreasonable force shall be used in making an arrest, and the person arrested shall not be subject to any greater restraint than is necessary for his detention. In the case of People versus Gairama, where the accused who had slashed the municipal president in his arm with a knife ran away and refused to be arrested, if the chief of police, who at that time had been armed with a revolver, shot the accused running away, the police would be justified. The court said that it is the duty of police officers to arrest violators of law not only when they are armed with a warrant of arrest, but also when they are not provided with such a warrant if the violation is committed in their presence, and this extends to cases where the purpose is merely to prevent the commission of a crime about to be consummated. The defensive actions in paragraphs 2, 3, and 4, in paragraphs 1, 2, and 3, as well as the state of necessity doctrine, they're all different from paragraph 5 because in the former, once the aggression has ceased, there's no further right to pursue. But in paragraph 5, the police officer, in the fulfillment of his duty, has the obligation to conquer his opponent. In other words, the person making the defense only has to repel or prevent the aggression, but the police must overcome his opponent. Now, with respect to an escaping prisoner, remember this rule. Firing at an escaping prisoner is justified only if the police officer is acting in self-defense or preventing the prisoner's escape. In the case of People versus De Lima, the court said that the killing by a policeman of a person who had escaped from prison once the policeman sees that escapee is done in the performance of a duty, because at the time the prisoner is committing the crime of evasion of sentence. You must know that in this case, the escapee had actually lunged at the police officer with a lance. That is why the police officer was justified in defending himself and even more justified in killing the policeman in the performance of, killing the escapee, because that would have been done in the performance of the police officer's duty. Now, in another case where the prisoner also attempted to escape and the custodians, the soldiers who were the custodians, shot him to death. In view of the fact that the prisoner, disregarding the warning of his custodians, persisted in his attempt to escape and there was no other remedy but to fire at him in order to prevent him from getting away, the court said that the soldiers acted in the fulfillment of duty. Now, all those rules notwithstanding, a prison guard is justified in shooting an escaping prisoner, but number one, there must be clear proof of an attempt to escape, and number two, he must try to fire warning shots first, if and when possible, of course. So, in the case of People versus De Lima, the prisoner who attacked the policeman with a stroke of his lance was already running away. Therefore, the unlawful aggression had ceased, but the killing was done in the fulfillment of duty. In People versus Bisa, when the guard leveled his gun at the escaping prisoner and the prisoner grabbed the muzzle of the gun, and in the struggle for its possession, the guard jerked away the gun from the hold of the prisoner, causing the latter to be thrown halfway around. And because of the force of the pull, the guard's finger squeezed the trigger, causing it to fire, hitting and killing the prisoner. Again, the court said that the guard was acting in fulfillment of duty. Okay, in summary, with respect to the fulfillment of duty, when is the use of deadly force justified? Number one, when the offender demonstrates lawless readiness to cause death or serious bodily harm, such that his apprehension must not be delayed. Or number two, when the offender is armed and shows readiness to use it. And number three, uh, in either case, the police officer must attempt or try first to fire warning shots. The court, in one case, there was an escaping prisoner, and the police officer shot him in the leg, and the prisoner fell. That was enough to immobilize the prisoner, but the police officer shot this prisoner who lay on the ground one more time, which shot turned out to be fatal. The court did not anymore say that this was in the fulfillment of duty, because the second requisite is that the injury should be the consequence of the fulfillment of duty, is a necessary consequence, which is not the case in the example just given. How about lawful exercise of an office? Suppose the accused is an executioner. Let's say we have the death penalty, and the accused was an executioner at the penitentiary. If he executes a death convict before the appointed time, that's not a lawful exercise of an office. The last circumstance is obedience to an order issued for some lawful purpose. The requisites are that an order is issued by a superior, that such order must be for some lawful purpose, and that the means used by the subordinate to carry out said order must be lawful. Both the person giving the order and the person executing the order must be acting within the authority prescribed by law. You should look at the good faith of the subordinate and the lawfulness of the order. Where the subordinate was not aware either of the lack of authority of his superior, or the superior's unlawful purpose in issuing the order, or where the order is patently lawful and the subordinate is not in any way negligent in ascertaining the true facts in relation thereto, then that would be a complete justifying circumstance. Suppose that X was the governor of, let's say, Batangas. His term ended on January, or let's say in September 15, 2020. After the end of his term, he instructed his chief of staff to dismiss another employee. Can the chief of staff invoke paragraph 6? No, because as of that time, he knew that X was no longer the governor of the city, of the province, or the province. Suppose the accused participated in the mass killing of the residents of the province of Bulacan. Later at the trial, he said that he simply followed the orders of his superiors in the Japanese army, Makapili, to kill those residents. Accused here would not be justified because although Makapili was organized to render military aid to the Japanese army, it was not until It was not part of the organization of the Japanese army. It was really a mere organization of Filipino traitors. Okay, that is the end of Article 11 on justifying circumstances. Thank you for listening, and if there's anything you want clarification on, please feel free to ask me anytime. Thank you.